Hello, I'm Sophie Kuemmel, an analyst at Oxera based in the Oxford office. Together with my colleague Roberto Alimonti, Oxera partner based in the Rome office, and our former colleague Thomas Now, we are honored to accept this year's Antitrust Writing Readers Award in the category Private Enforcement for our academic article on the interplay between leniency programs and private enforcement. Thank you to the jury and to everyone who read and voted for our article. What triggered our article was the overall low number of leniency applications in the EU in the last few years. There's some evidence to suggest that this trend has turned around over the last 12 months. However, at the time when we wrote the article, many practitioners were concerned that private enforcement claims may be partially responsible for the low number of applications. These considerations are still relevant now, as the number of leniency applications has increased but may still not have reached optimal levels. To give more context, the 2014 Damages Directive establishes that any infringement sanctioned by a competition authority can be viewed as irrefutably established afterwards, and that any firm or person that has been harmed by this cartel has the right to compensation through civil damages. This means that a leniency application carries the risk that a company may be sued for damages afterwards, as the firm has to admit its membership in a cartel as part of her application to receive partial or full immunity of antitrust fines. In our article, we discuss different recent policy proposals that aim to ensure that leniency programs and private enforcement are more aligned. Specifically, we argue that immunity from administrative fines should be extended to immunity from follow-on antitrust damages, as this has been shown to significantly increase cartel deterrence. We also argue that this option should be available to all firms, rather than just those not holding a dominant position, as it is, for example, often very hard for a firm to self-assess from an ex-ante perspective whether they're dominant. Similarly, we advise against the proposal to grant extended leniency only if the other cartel participants are able to pay damages caused by the leniency applicants, as it again requires firms to be able to self-assess, from an ex-ante perspective, the harm that they've caused. Finally, we find that providing claimants with full access to leniency statements may harm the business relationships of the leniency applicant, and therefore represent a significant disincentive to apply for leniency. Overall, we therefore only consider extending immunity from administrative fines to follow-on antitrust damages as a viable option to increase firms' incentive to apply for leniency. All others seem to entail significant difficulties from our perspective. Thank you.